Before we start, Mr. Beluga, did you bring some interns? Or?
Yes, I did, Your Honor.
All right, why don't you go ahead and they can introduce themselves and where they're going to school.
Absolutely.
I'm Ann Thorne. I go to school at St. Mary's University. I'm Allison Lane. I go to University of Florida. I'm Kelly Schultz. I go to University of Florida.
And I'm John Durrani, and I go to the University of Alabama.
Okay, well, we're pretty pleased with the Florida grads. I don't know about Alabama.
I thought that may be a problem.
You're welcome.
Thank you, Your Honor.
Okay, how much time do you want to reserve for rebuttal?
I'll reserve 5 minutes.
All right, you may proceed.
If it please the court, my name is Tom Hippelhauser. I'm here for the Mr. and Mr. Berrios in a lawsuit against Orlando Regional Healthcare. This is a case that stems or is the result of a very well thought out rule of equity that morphs itself into a rule of law that becomes rigid and doesn't apply to the facts as it should. As you know, we're here on a motion for summary judgment. My client, THERESA specifically, was injured in the state of Georgia while she was up there on a vacation. As a result of that injury, she returned to the Orlando area where she received medical care. And in the course of that medical care, she actually spent, I believe, 6 days in ICU in a coma, another 3 days in ICU, deciding whether she was going to stay out of the coma, and then a couple more days in the regular hospital before she was released. Sometime during that stay in the hospital, she became the victim of medical malpractice and suffered damage to her leg. She and her husband proceeded to file a lawsuit in the state of Georgia arising out of the original tort action. And while up in Georgia, they reached a settlement of that original tort action and entered into a release agreement. The release agreement complied completely with the laws of the state of Georgia. And in the state of Georgia, the rule is you do not include anybody in the release that's not intended to be released. After settling that case, they returned to Florida and proceeded to file a lawsuit against the hospital for the medical negligence that she sustained while she was in the hospital. That led to the motion for summary judgment, and the grounds were that the hospital was not specifically excluded from the release in the language of the release, which is apparently a rule of law under this court. Has actually got the controlling case on it in the Rux versus Pushman case. The issue we have is that if you read the entire Rux case, which was a well thought out and well discussed case on what the problem was, you see that what they're trying to do is deal with situations where the release is not clear on what the intent of the parties is. And that when you have a subsequent tortfeasor case, the initial tortfeasor is liable for the subsequent tort. And so when they settle, what was the intention of those parties? Was it the intention was to just settle the initial tort, or was the intention to settle the entire case? And what this court said was, in those situations when you cannot tell what the intent of the parties is, we're going to make a legal presumption that in Florida, if you don't exclude them from the release, then the deal was to settle the entire case, and then the initial tortfeasor, through the doctrine of equitable subrogation, gets the rights to go after the subsequent tortfeasor. It's interesting at this point to note that the rationale of the entire doctrine of equitable subrogation was a malpractice case, and what the Florida Supreme Court said was, we're tired of hospitals getting away with committing malpractice and not being held responsible for their actions. And so they created the doctrine to where the initial tortfeasor, after buying the whole case, can go after the doctors. Well, if you look at the Rux case, the longest part of the entire case, other than the analysis of the problem, is the last head note, which talks about, however, justice requires that when the intent of the parties is determined or can be determined, that this rule doesn't apply. That's not going to be so ingrained in stone that we're going to go ahead and say if you don't put some magic language in a release, but we can decide the intent of the parties otherwise, that in this case, hospital gets off with not paying anything. Well, in our particular case, what trial counsel did is obtained affidavits of all of the parties to the original release. Those affidavits clearly said that there was no intention in entering into that release to release the hospital. And there wouldn't have been, because the law in Georgia is if the insurance company for the resort wanted to go after the hospital, they had to put that language into the release. By them choosing not to, it's pretty clear that their intent wasn't to do it, wasn't to buy some subrogation rights. And then their affidavit made it clear that it was not the intent of the BERRIOS to settle the entire claim. In our brief, we kind of danced around the value of the settlement because of the confidentiality agreement, but the total amount of the settlement was $75,000. If you look at the medical bills alone that these folks incurred spending the time they did in these folks' hospital, you can see that that's not an adequate settlement for that claim and for the permanent injury she sustained to her leg. Not to mention, on top of it, her husband lost a month of work as a consultant, and now she's on disability and can't work. So I don't believe that the concerns that are always raised in these cases, they always seem to be the concerns that benefit the hospital.
Do you think your case is stronger if Georgia law applies?
Absolutely.
All right, why do you believe Georgia law applies?
Because the contract was entered in Georgia, but to settle a cause of action that accrued in Georgia, and it was intended to resolve a lawsuit that was initiated in the state of Georgia. Now, on the issues that the courts are always concerned about, double recovery. We don't believe there's any facts that would support double recovery, but even if there are, that's something that's disputed fact that should be sent back to the court. There's absolutely no chance of double payment here. Any competent attorney for the hospital would file immediately a motion to dismiss if the Dillard House tried to raise subrogation, because Georgia law would bar them from doing that, and this is a Georgia contract. So that what we're stuck with then is the problem that equitable subrogation was designed to cure, the hospital getting away without having to pay for the harm they caused. We just don't think that this is a just result under these facts. My clients did everything they could to demonstrate their intent. They produced the affidavits. We've just demonstrated what Georgia law is on the issue of the subrogation, and I think this is a case where the court could easily determine, if we filed a motion for summary judgment, that the facts are determined, but at least on their motion that there's got to be a finding that there's disputed facts at best on their intent and should go to the fact finder. But I think we've established clearly what the intent of the parties was. I don't have anything else unless you have questions.
All right, thank you.
Good morning. May it please the court. My name is Michael DeLugo. I'm here on behalf of Orlando Health. And I believe that the summary judgment that the trial court entered was appropriately entered and that it should be affirmed on appeal because of the application of the Rux decision to the specific crystallized facts of this case. There are no disputed issues as to any of the material facts in this case. Ms. Berrios went on vacation.
Well, the material issue, is it not, whether or not the Georgia case even include the claim against the hospital?
Well, I think that the allegations of the Georgia complaint make it clear that the Dillard House was sued for the injuries that Ms. Berrios experienced.
It doesn't mention leg damage. It doesn't mention anything like it. It doesn't mention malpractice. It doesn't mention doctors.
It mentioned that she suffered a perineal nerve injury to her leg. That's in paragraph 21 of the Georgia lawsuit.
To her leg?
To her leg, as a result of her stay at South Seminole Hospital. It clearly specifically addresses that she suffered an injury in South Seminole Hospital, a perineal nerve damage injury.
I missed that in the complaint. I'm sorry.
And also, Your Honor, if you look at count 4 of the complaint, of the Georgia complaint, that is for wrongful disability, and Ms. Berrios testified in her deposition that the only injury that caused her disability was the perineal nerve damage to her neck. The Legionnaire's disease was treated and resolved, and that had nothing to do with the disability. So in the lawsuit, the Georgia lawsuit, there are two specific allegations that relate solely to the injuries that Ms. Berrios experienced at South Seminole Hospital.
Let me ask you this. If we determine that Georgia law applied, and we'll get to that issue in a second, but if we determine Georgia law applied, what would the outcome of this case be?
I believe that Georgia law is the exact opposite of Florida law
So the
on this
appellant
issue.
would be successful on this appeal?
So I believe so. I would argue that Florida law should apply to a Florida claim of malpractice brought against a Florida hospital and brought pursuant to Chapter 766. This case went through the whole pre-suit. I don't think there's any legitimate basis to claim that the malpractice claim against Orlando Health should have Georgia law applied to it.
Well, let me ask you this. If say, we'll add to the hypothetical, or make a hypothetical here. If after the plaintiff had gone to Florida and got treated, and they then referred her to another state, let's say North Carolina, to Dr. North Carolina, and she went up there, and then she ends up and decides that there's been malpractice by the doctors in North Carolina, there's been malpractice by the doctors in Florida, and she enters this settlement first in Georgia and enters this release, and North Carolina has the same law as Georgia as far as the presumption on the release. Would that mean that she could bring an action against the doctors in North Carolina but couldn't in Florida? If I understand the hypothetical correctly, I think that is true, because the law in North Carolina is different than the law in Florida. Can the release have more than one interpretation? Or does somewhere along the line the judge has to say, this is what this release means?
There can be two different interpretations if there are two different states' laws that apply, and those two states' laws are diametrically opposed to one another.
Well, there may be two interpretations, but how many conclusions, if you would, how many judicial determinations can there be?
There would be one in Florida and there would be one in North Carolina, and they may be inconsistent with one another, but that would be based entirely on the fact that under your hypothetical, the law in North Carolina is different than the law in Florida. So,
well, isn't that the purpose of the conflict of law cases, is to prevent a scenario where you have two different, well, one of the intents could be so you don't have two different interpretations of a contract, depending on what state you're in, so instead you say this state's law controls under this scenario.
I agree, and in this case, not using your hypothetical, but using the actual facts of this case, this is a Florida lawsuit against a Florida hospital alleging Florida malpractice, and therefore Florida law should apply. Now, the fact that the release happened to have been entered into in Georgia is a fact in this case. I don't dispute that, but I don't believe it changes the Rux analysis. You still have an initial and a subsequent tortfeasor. You still have an injury that is caused by the negligence of the initial tortfeasor, and that while that specific injury is being treated in Orlando Health, there is an allegation of malpractice resulting in a separate and distinct injury. Under those facts, Dillard House, the initial tortfeasor, is liable for those injuries that Ms. Berrios allegedly suffered at Orlando Health. She sued Dillard House and specifically alleged that she suffered a perineal knee injury while she was receiving treatment for the Legionnaire's disease. She specifically included in her lawsuit against Dillard House that she was suing for wrongful disability, and she testified under oath that her disability was based solely on the perineal knee injury. So she sued Dillard House for those specific injuries, and then she entered into a release where she released any and all claims of any and all known and unknown, foreseen and unforeseen bodily and personal injuries for which we have claimed the releasees to be legally liable, the releasees in this case being Dillard House. So they're releasing every claim that they had, and as a matter of Florida law, one of the claims that they had was the claim against South Seminole or Orlando Health for the injuries that Ms. Berrios suffered.
Let me ask you this, if I may, please. The basis of the Georgia law, as I understand it, is because a party, not a party to the agreement, claimed coverage, that created an ambiguity that Georgia is going to construe by parole evidence or have a rule of law. What is it that, but suppose the agreement itself, the release itself, which releases its claim, say, against the hospital, is not ambiguous. Would the Georgia law apply to that? As I understand it, all they're claiming is that you have not released this person from the Florida lawsuit, not that somehow parole evidence is going to permit some testimony concerning an unambiguous release of the claim. I hope I make myself clear on it.
Well, Your Honor, if I understand correctly, I mean, I don't believe that, first of all, I don't believe that the release in this case is ambiguous. I think it's absolutely crystal clear. And under those circumstances, you cannot look to the parole evidence that was introduced, and therefore I would suggest that the affidavits that were submitted to the trial court can be ignored because there are not permissible analysis.
Well, to me, the real issue is, has there been or would there possibly be double recovery?
Well, I mean, that is a subjective analysis of what the underlying claim is worth. And I don't know that we can go behind the unambiguous, clear language of the release to reach the conclusion that, oh, this is going to be, she was not adequately compensated. If that were the case, if that were the analysis, then no release would ever be final because a claimant could turn around after it's been signed and said, oh, well, that's not what I meant. I didn't mean this was final. I still want to sue you again. You can't do that. There has to be some finality when you enter into a release, especially a release like with the language here. And I asked the court to look at page 208 of the record because the release, it could not be more clear that it releases every claim that they made against Dillard House, and they specifically sued Dillard House for the injuries that she suffered at Orlando Health. And so I think under the specific facts of this case, applying the Rux decision, looking at the specific language of both the Georgia lawsuit as well as the release of Dillard House, I think leads to the inescapable conclusion that the cause of action for Ms. BERRIOS went away with the execution of that release, and she cannot sue Orlando Health.
What do you think our dictum meant in the Rux case at the end of the opinion?
The dictum in Rux suggests the way to fix this problem if the plaintiff believes that the cause of action was improperly transferred to the initial tortfeasor. And they can do one of two things. They can either initiate an action, a separate action against the initial tortfeasor for reformation of that agreement, or they can ask the initial tortfeasor to simply assign the rights that they have against the subsequent tortfeasor back to the claimant. Neither one of those things happened here. There's no record evidence to suggest that either one of those things happened here. Instead, there were affidavits that were submitted, but again, I would argue that those affidavits shouldn't be considered because the contract, the settlement release, is unambiguous, and therefore we don't go to parole evidence to divine the intent of the parties. The intent of the parties is contained within the four corners of that agreement, and there is no confusion about what is being released. There's no confusion about what's being sued for in the language of the complaint, and there's no confusion about what's being released when they enter into that settlement agreement. And because of the language, the specific language of both the Georgia lawsuit and the release, the cause of action went away at the time of the execution of the release, and that's why summary judgment in favor of Orlando Health was proper.
I have trouble with your contention that the language of the release is clear and unambiguous because the whole reason Georgia and Florida law is conflicting on it is because, Florida says, well, we can't, it's not clear from this language of this release, therefore we're going to presume A. And Georgia is saying, it's not clear from the language of this type of release, therefore we're going to presume the opposite. So to me, it's not clear and unambiguous, and that's why, Florida's got one presumption and Georgia goes the other way.
I understand what you're saying, and I agree with you. But I would say that because Florida law applies to this case, we need to apply Florida law. The reason why I said that the release is clear is because, again, it says that it's releasing any and all claims of any and all known and unknown, foreseen and unforeseen bodily and personal injuries for which we have claimed said releasees to be legally liable. And once again, that's at page 208 of the record. I think that when you have language like that, it is a clear and unequivocal release of every claim that they have, and they knew that they had this claim against Orlando Health because they said in the Georgia complaint that she suffered perineal nerve damage as a result of the treatment that she received at Orlando Health for the injuries she suffered at Dillard House. And also, if you look at paragraph 45 of the complaint, because she's claiming wrongful disability when in fact she testified in her deposition that the only cause of her wrongful disability is the injury that she suffered at Orlando Health.
What is the paragraph, again, where they allege the negligence in Florida?
The paragraph 21 is at page 177 of the record, and it states, during Teresa Marie Berrios' stay at South Seminole Hospital, she sustained yet another injury to the peroneal nerve of her right leg, rendering the leg motionless from the knee down. And then at page 180 of the record, that's count 4 of the Georgia complaint, is a cause of action for wrongful disability. And again, she testified under oath in her deposition that the only source of her disability was the knee damage, the nerve damage.
So you're saying that at any situation like this, where there's a release interpreted under Florida law, you would take the position that if the initial tortfeasor sought indemnification or subrogation against you, you would not try to use the rule of lex loci as a defense. Is that what you're saying?
No, Your Honor. What I would say is that when you have a release where you have a situation where you've got an initial tortfeasor and a subsequent tortfeasor, all you have to do is put one sentence in that release saying, nothing in this release releases the subsequent tortfeasor, and the claimant intends to pursue the subsequent tortfeasor for all claims related to the injury suffered as a result of the negligence of the subsequent tortfeasor. That's all that has to happen, and it just didn't happen in this case. And it's not the first time that the release language under this scenario has occurred. In addition to the Rux decision, there are a number of decisions from other district courts of appeal that hold the same thing in the context of an initial and subsequent tortfeasor, where the subsequent tortfeasor is a healthcare provider who causes injury through malpractice while treating the injury suffered as a result of the initial tort.
So if we accepted the truth of the affidavits that the parties never intended to fully that there was a full compensation under this, you would be saying that the parties wrongfully or mistakenly relied on Georgia law. Is that what you're saying?
Well, first of all, I would say that you can't get to the affidavits because that's their parole evidence, and also the affidavit of the nationwide adjuster is hearsay because all she's talking about is what Ms. Berrios told her.
But shouldn't parties in a state where they're drafting a document such as a release reasonably be entitled to rely upon the prevailing law in that state?
To the extent that the contract is going to be enforced by the laws of that state, then I would say yes. However, because she knew that she suffered an injury in Florida that could possibly have been the result of medical malpractice, which would result in a Florida lawsuit, then you need to be careful about how you draft that release, because it's going to be, I believe, it should be construed under Florida law when the lawsuit is brought in Florida for a Florida tort. And
are you aware of any cases where, you know, you've had this issue where it's a release, you have two states, different laws on a release, and you know, actions brought in a different state than where the release is?
I am not, Your Honor.
Okay. I think Georgia may have a case with Florida where they said the Florida release applied. So, all right. Thank you.
I don't have anything further. Otherwise, if you have no more questions, I will rely on the contents of our briefs. Thank you.
I notice you didn't challenge the fact anywhere that the Georgia complaint covered the Florida claim. Is that correct?
That's correct.
You agree it did?
Yes.
Can't the release, in addition to releasing someone, release the claim? In other words, maybe it didn't release the defendant by name or by act of Georgia law from the lawsuit, or from bringing a lawsuit, but didn't it release the claim? And if you release the claim, what difference does it make if you release the individual?
I think the court in Lackey, Lackey or Posey in Georgia addressed that issue, and they said that it needs to be more than that. It needs to be either the person or a description of the person to be.
Well, that's to get the release of the person, but I'm talking about the claim itself. If you have been paid, if you acknowledge in this release, which can also be a receipt, I have been paid for this Florida claim, therefore hospital, or therefore resort, you are now subrogated to my rights, go down and sue the hospital, then you no longer have a claim, do you?
If you look at the language in Posey when they're talking about the problem, they deal with the situation of how do we interpret this kind of boilerplate language. And the language in that release is no different than the language you see in the
Well, I
standard
thought it was
release.
boilerplate till I found out you actually sued for the Florida claim.
After Posey came down, there were a couple of failed attempts in Georgia to deal with the issue that you're addressing. One was have an open parole evidence situation to find out exactly whether a claim was fully satisfied or fully released. And that was the issue that came up on Lackey. And what the court said was, that's not working. The rule in Georgia is, with this now knowledge we have on trying to apply Posey, is if you want to buy these subrogation rights, you need to put that party in the release. And it's addressed to the initial tortfeasor and their rights to pursue a claim. And the whole argument in Rux is that the reason my client doesn't have a claim against the hospital is because Dillard House has it. In Georgia, Dillard House does not have it.
There is no right, no right to equitable subrogation in Georgia.
There is if it's specifically, well, equitable, probably not, under Lackey. Contractual, absolutely. If you specifically
Georgia
transfer.
law, Dillard House could not bring an action against the hospital
Not unless they...
because of the release language.
Because of the release language, yes. If they were actually listed in the release, then the law would, I guess, imply equitable subrogation. You would have to go all the way to the point of saying, and we assign our rights. But if you say under Georgia release, we're releasing the claim against Dillard House and the hospital, under that facts, then there's equitable subrogation to Dillard House.
Well, didn't they do that?
They didn't release the hospital in the release. It's not named. See, he's arguing that you need to reserve it. In Georgia, you need to name it. You need to tell them that that claim is being released.
So is your position that at this moment that no one can bring an action against the hospital?
That's correct. One other thing he mentioned briefly about the procedures. It was mostly discussed in the briefs, but I didn't brief it when I did mine, and I apologize. The Alexander versus Kirkman case, which was a pre-Rooks case, dealt with the issue of this reformation. And under our facts, there's nothing to reform because Georgia law is what it is, and there's nothing to reassign because the folks up there didn't actually get anything. And what Alexander did is they filed a reformation action. And the other side answered in the reformation action admitting that the intent was as pled in the reformation action, and it never went any further than that. And that court said that was good enough with affidavits. You didn't actually have to get to the point where there was a ruling reforming it. It was enough to show the intent of both of the parties because both parties made a statement of what the intent was. Every other case that's come up, as I call them a Rux failed attempt, has been a unilateral attempt on the plaintiff's side to try to establish the intent. In Rux itself, it was a reformation action that never went anywhere. There's been unilateral affidavits. In this particular case, we have bilateral statements as to the intent of the parties.
What were the facts of last year? I cannot remember. What were the facts of the case that you say deals with the subrogation rights of the hospital?
In Rux?
No, in your Georgia case.
All the facts are exactly the same. There's a initial tort, and I think Posey, it may have been an auto accident and a malpractice. Lackey was a case that actually was joint tortfeasors. But what they did in their ruling is they said that our ruling in Posey applies to all cases subsequent.
What was the ambiguity on the settlement itself, not the parties, that justified the parole evidence?
The same language that's in these general releases, that it's a release of all claims, and it didn't name the specific party who was trying to claim protection. In that particular case, it was a joint tortfeasor, and Posey was a subsequent tortfeasor, but it's always the third guy trying to claim that release applies to me. And what the Georgia court said, unless you're named in it, it's not intended to be
that seems to say they make no distinction in a settlement of a claim, or a release of a claim and a release of a person. Is that the Georgia law? There is no distinction between the two?
There's talk in the Georgia analysis about the same issues that are in Rux, that it has to be unclear to the court what the parties intended. And I think if the parties make it quite clear.
If it's clear that the release satisfies the claim, as opposed to releasing the individual, under Georgia law, you can still use parole evidence?
I think if the release would go on to say something like, we're going to go ahead and release all claims, including any malpractice claims that may arise out of this accident, I think the Georgia court may interpret that as being clear and unambiguous, but not just some generic boilerplate language.
Interpreting clear and unambiguous, that can be done in Florida. That has nothing to do with Georgia law, does it?
Well, the
question is, if it requires an ambiguity, then this is the court to determine if there's an ambiguity.
Well, I think all the cases that talk about this, both in Georgia and Florida, assume that there's an ambiguity. And it's what the trial court did. He applied Rux, and Rux was an ambiguity case. The trial court said that based on the authority of Rux, we're going to presume that since this party was not reserved in the release, that it was not the intent of the parties to reserve it. That's a presumption case.
That's the party and not the claim. Okay. Thank you.
Well, I don't see the distinction when we're talking about this boilerplate type language.
Anything else? All right, thank you. It's an interesting case. It'd be a good one to put on a law school final.